Okay, so we are going to continue with what? Liability for the act of the what? Of the company. Liability for the act of the company. Okay, so we started in our last class with section 89. Is that not so? You have to open your camera, you know the way you do now. Once it is a partnership. If you have it on your phone, you have to open it. So we started with what? Section 89. And from section 89, I told you that there are some things that you should always pay attention to. Hello? I said from section 89, we have been able to establish that section 89 only deals with what? With the acts of the what? Of the primary organs. Is that not so? The act of the what? That's what we do after class now. Liability for the act of the what? Of the company. Section 89 only applies where it is any of the primary organs that does what? The act. And we have been able to establish that the primary organs are, who are the primary organs? I don't want to know either the what? The board of directors, members in general meeting, managing director. On what authority? Members in general meeting, board of directors. The authority is 87 sub 1. That's what makes them to the primary organs. It says that what? The company shall act through what? Members in general meeting or the what? Board of directors. And I've told you that from Freeman and Lockyer versus Locus Park, the company can only act through what? Human law agents. Are you following? The reason we call them organs are whatever they do, it is deemed as what the company will acting. Are you following? You get that? So that is one. But for managing director, you know that 87 someone did not mention managing director. So we said the one that was made mention of managing director and made the managing director to be also regarded as a primary organ in section 89, because it now mentions what? The managing director. And I told you that there is a reason why you have to understand that 89 deals with what? Any act of the what? Of this what? Primary organ. Because the secondary organs too, they may also what? Make what? The company to be what? Liable. So don't go and be citing section 89 when the question you are attempting made mention of maybe the secretary or made mention of maybe what? A particular director, not what? The board of directors. They don't mention what? 89. You only mention 89 where it involves what? The primary organs. Either the board of directors decided something and the company is what? Is liable. Are you following? Or the members in general meeting, in that general meeting, they made a decision. The company is what? Liable. The managing director does something, the company is what? Liable. Under what? 89. I don't know whether do you understand that? Are you following? I'm reading this for the purpose of those that were not around. So that even when you are reading, you don't get confused. And I told you that the reason this is also important is because when you look at section 87 sub 1, section 87 sub 1 is the section that determines what the organs of the company. It says the company shall act through what? Members in general meeting or what? Board of what? Director. But it proceeds to also say that what? Or through what? Officers or what? Agents appointed by or under the authority of the board of directors or the what? The members in general what? Meeting. And that's why I feel that the board of directors, they can, in discharging their duties, they may delegate. Do you understand? Say, so when they delegate, now when you are talking about the act of that particular person, not the board of directors in this what instance, you are not considering what 89. You will be considering what 90. Do you understand what I'm saying? I'm saying this because if you see a problem question, so you will know the one to what the section to what to talk more about. Do you get? Now, generally, the wording of 89 says any act of the members in general meeting, board of directors, or managing director, while carrying on business in the usual way, then it shall be treated as the act of the company itself. And the company will be criminally and civilly liable to the same extent as if it was a natural person. So if the MD, if the board of directors, if the members in general meeting, if they should carry out any action in the usual way of doing business, it is deemed as what the company has carried out the action. I don't know whether you follow. Do you understand? And because the company is considered, the company is placed on the same pedestal as what? as a natural war person. Are you following? I told you that the reason a company is having organs is to what? So that the company will be able to live what its life as what as a legal war person. It's an implication of the corporate personality that we've learned in war in first war semester. So if any of these people should act, they can make the company to be criminally war liable, and they can make the company to be civilly war liable. And I gave you an instance, an illustration of this to show you where a company can actually be criminally liable. We looked at what section 269, is that not so? Sub 4. What does 269 sub 4 say? That's what that more or less indirectly prohibits every company from what? From having de facto or directors. You've done at least you started a board of directors, so you should know. 269, who can read 269 for us? Oh, why are you reading it? Some of you wrote it in last class now. You'll be able to see something about this. Remember your 269 now. Speaking about what? He said the director is what? Anyone that was duly war appointed. He said that is what? The job war director. Director according to what? To law. Sub 2 allows you to presume that anybody that the company describes as what? As a director is what? A director. Do you get? I think, is anyone at 269? Yeah. What does 269 say? 269 sub 4. It says if it is the company that holds what him out as a what? As a director. If it is the company that holds him out as a director, it is liable to a fine in such amount as the work commission shall specify. If you are liable to a fine, that is what? That is a crime. Do you understand what I'm saying? So you can see an instance upon which what a company can actually be criminally liable. If the company should hold someone that is not duly appointed as what? Hold him out as what? As a director, that is a de facto director, that company can be criminally liable. But you see, 26944 kept saying company. The question is, who is the what? Is the company? Yes, it just says company. If the company should hold somebody out as what? As a director, where he has not been duly appointed, who is the company? Who can hold somebody out? Who can hold what? Somebody out as what? As a de facto director, and the company will be held liable. Because when you say that they will pay such fine as the commission may determine, does it mean that if I'm a director, it is in my own pocket I'll pay? Of course not. It is the company's assets. And the company will use in pay. If it is the company that holds the person out. Who is the company? I'm asking a question. Only the board of directors. Can be the board of directors. It can be what? The members in general meeting. It can even be what? The managing director. But they are seen as what? The primary organs of the company. And that's why I told you that Professor Boa said that when you see any provision that did not say board of directors has more power, that did not say what? Members in general meeting has more power, but that just says what? Company. The company can either be the board of directors or the members in general meeting. Are you following? But I told you that if you want to define your company, it is 7 sub 3. What does it say? It says first, the general powers to manage what any business lies with what? With the board of directors, because subject to the provisions of the articles of association. So if there is any issue, and Kama has not defined whether it is the board of directors, whether it is members in general meeting that has more power, you can use your articles of association to define it. Are you following? But what if you do not define it? What will happen? Who will now be able to exercise it? The board of directors, because the general power revolves around the board of directors. Are you following? So I'm not saying that what if the general power has resolved or that been brought in the board of directors, the board of directors then refuses, or the board of directors is unable to exercise it, then who will then exercise it? On what authority? On the basis of 87 sub 5. That's the reserved power. Gave you these instances. Said if there's any issue you want to determine who has power, check Kama. Kama will most likely have defined who should, whether it's the board of directors or the members in general meeting. Right? If Kama does not say anything, where do you check? You check the articles of association. If the article of association does not say anything, then automatically it is the board of directors that can exercise it. But if the board of directors become unable to exercise it, then that means what? The members in general meeting will then war exercise. Are you following? So from 89, we have been able to see. But then it starts, 89 has certain provisions that more or less provide for exceptions. Exceptions when these organs would act, and yet it will not be deemed as what as the act of the war company. Said the company shall not incur civil liability if the person had what actual war knowledge. If you had what actual knowledge at the time of the transaction in question, that the general meeting, the board of directors or MD, as the case may be, had no power to act in the war matter. So, if for instance you know that this particular power is not the board of directors that is supposed to exercise, that is the members in general meeting, but yet you dealt with the board of directors. That actual knowledge automatically means that the company cannot be civilly liable because you did. But then we said it's not only about actual knowledge, there's also imputed knowledge. The imputed knowledge part is one that says, or in the act, in the matter, or an acting in an irregular manner, or of having regard to his position, of having regard to his position or relationship to the company. You see that aspect of you did not have actual knowledge, but having regard to your position or to the relationship that you share with the company, you ought to know. That was when I took you through the policy of the law behind the law of negligence. That is not only when you intentionally did something, you knew when you did something that you are deemed to be guilty or blameworthy. When you ought to know, can also be deemed to be blameworthy. I told you that this imputed knowledge can be understood within two levels, because it said either due to your position or to your relationship. How can imputed knowledge arise? Either by way of your position. You are a director, and you are dealing with the board of directors on a matter. As a director, you are expected to know the matters in which the board of directors can act and the matters in which they cannot act. Don't forget that the legal incidence of the company being a person is that a company can contract even with its members. So because I'm a director does not mean I cannot say I want to borrow the company money, my own money. Do you understand what I'm saying? When you want to borrow the company money, you are supposed to know who that you are supposed to deal with. Are you following me? In that instance, that is what it means by your position. But when it says relationship, gave you the instance, it said if you are their long-time customer, you've always been dealing with the company. Do you understand what I'm saying? You've always been dealing with the company. And this is the way you do the thing. So why is it that this time around, things change and did not put you on alert, except where the company has held has given you the impression that you can go that way, and that is what led us to ostensible authority. But remember that 89A has nothing with ostensible authority, actual imputed knowledge. Do you understand what I'm saying? Now, B says if in fact the business is being carried on by the company shall not escape liability. B part has to do with the fact that they had acted contrary to whatever it is that they have stated in their memo, does not mean that the company will not still be held liable. I told you that this is another provision that tones down the rigidity of the Shabbat rule. And I said when you are reading this 89B, also join it with the provision of section 44 was sub 3. Do you get what I'm saying? Section 44 sub 3. If the business is not authorized, it does not automatically mean that if the company should act, that the company can now come back and say, well, the business is not authorized, so they did not have to come. No, the company has acted. Do you understand what I'm saying? The company has acted. But then I raised the issue of that if you now look at our new section 44 that has changed from not authorized to expressly prohibited, how can the business be deemed not to have been authorized by the memo so as to apply section 89 B? Because now they are saying it's only business that has been expressly prohibited. It's when the company does a business that has expressly prohibited that the company will be held to have acted or travel. Do you understand? That's the main position. But what we are saying is, what if what the company did in this instance has not been stated in the memo. Remember that we still have our section 27(1) C, meaning you must still state the nature of your business in your memo. The only thing is just that even if you do not state it, you can still go ahead and do it. Particularly if you do not state any restriction in your articles of association according to section 35. You can go ahead and do it. The only things you cannot do is anything you have expressly prohibited. But now we are saying that, say a company says, oh, we can never involve ourselves in selling rights. In selling rights. And then you, Palumi, dealt with what? With the board of directors. The board of directors is somewhat confused. You dealt with the managing director. On the basis that you are supposed to supply the company more rights and this and everything and all. When you guys have entered into the contract and blah blah, only for one of them to raise the issue of no. Right? You are meeting with the managing director, it's not the company that will pay you, and they're not showing you that we come and see in our memorandum of association. We have expressly prohibited ourselves from getting involved with any business that has to do with selling, buying, and everything or price. That is what your 89B is talking about. That the fact that it has not been authorized. Because if you expressly prohibit something, that means you are not authorizing it. The fact that it has not been authorized is not a case for the company to still avoid liability. Do you understand what I'm saying? So they told that Ultraviolet in. But you know that the policy of our corporate regime now is that Ultraviolet is still important, but not all that important, particularly where a third party is involved. You use Ultraviolet within the company. Do you understand what I'm saying? Within the company you can use Ultraviolet. But once the third party is involved, and the third party is blameless, that's why you see that the whole idea of actual knowledge comes in. So the question is, if before you came to deal with me, the managing director, you had already checked the memorandum of association, and you saw it there that we have expressly prohibited and don't do sale of rights, and yet you proceeded to deal with me. With this 89D still apply to make the company to go live? It's a question. Did you get the question? You know, 89B is saying that it does not matter that the business you dealt with the company has been expressly has not been authorized in the memo. It does not matter. The company is still live. That's what 89B is all about. But I'm not saying that. What about when you, the third party, you knew, of course, you knew the content of the memo, that is actual knowledge that business was not authorized, and yet you went ahead and you dealt with the company. Would you be held would the company still be held live according to its ID?
I don't think so. As long as the company is carrying on.
You're not getting. The company is carrying on the business, fine. But then we are saying that you actually had actual knowledge. That despite the fact that the company is carrying on the business of selling rice and everything, you saw it in the memo that they are expressly prohibited. You know the way companies and the way they work, they are mad. You probably would have been dealing with the company for years, selling rice to them. They know that they said they should not be buying rice. You know, but you guys have been doing it like that. Why? Because nobody has come to challenge that. Are you following? So it's proceed. Until one person wakes up one day and then challenges that. Of course, what 89B is saying is that you are supposed to be protected as a third party. But it's in this instance, I'm not saying that the third party was actually even aware that the company was not supposed to be getting involved in that business. So I'm not saying in this instance will the law still protect the third party, or will company be held on? The law will not. Why?
There was actual knowledge, and then it's now maybe provide for
I'm asking you a question, I have not answered it. So
it still protects you.
It still protects the third party even when you had actual knowledge. Is that what you are saying? The company is still reliable. Why? On what basis? What is the authority for that? It's not the fact that you had actual knowledge.
It's not to provide for the retirement of knowledge on the part of the
Because 89B does not provide for knowledge. Okay. We are going to check other provisions of what? Of the Act. And when you look at some of these provisions, listen, how are you picking pen? Why did everybody pick pen?
It's fun now.
Expressly prohibit, they are saying you cannot. In the memo. You know that by the time you go to what presumption of regularity and the abolition of what constructive or notice, the law says, well, it's not a must that you know whatever it is that was the content of the words of the mention. But then by the time we begin to look at some of the exceptions to what abolition of what your constructive notice and presumption of what regularity, you will see where what your actual knowledge will make you. Don't worry, when we get there, you yourself will get an answer to that particular instance. Now, section 90 is the one that deals with what the act of war, officers of war, agents, as being deemed as what the act of the war company. So you have to be able to create that distinction. 89 organs, primary organs. 90 secondary war organs. Are you following me? So when you are dealing with the director, dealing with the secretary or whatever, you have war 89. And he said, except as provided in section 89 of this act, the act of any officer or agent of a company shall not be deemed to the act of the company unless the company actually through its members in general meeting, board of directors, managing director shall have expressly or impliedly. So that means section 89 is also another section that basically shows that what the managing director is what a primary war organ. You see that it's mentioned the managing director alongside the members in general meeting and the board of war directors. Now, I told you that you have to appreciate what do I put it? The silent distinction between 89 and 90. Under 89, look at the wording. The wording says the act of these people are deemed to war, the act of the company, unless this. For 90, he's saying ordinarily, generally, the act of officers or agents are not the act of the war company, unless. Can you see that? Two things are different. In the primary organs, inherently in them, their acts are the act of the war company, naturally. Except you are now able to prove actual knowledge, imputed war knowledge. But if you are an officer, agent, whatever, employee of the company, whatever, ordinarily, naturally, generally, from the beginning, you are not what? Your act is not the act of the war of the company. Except you can prove some of these words, some of the things. And one of the things you have to prove is that what? You have either the word expressly or what? Impliedly war authorized. By who? By the primary war organs. Hello? By the primary organ. You see, when you are interpreting section 19 subsection 1A, read it alongside your 87 sub war 1. And someone says you can what? That the company shall act through members in general meeting, board of directors, or officers or what? Agents authorized or appointed what? Appointed that. So this is one instance of appointment. You read section 90 sub 1A, read it alongside section 87 sub 1. It will make sense. Because 87 sub 1 is still saying that even outside these primary organs, there are instances in which the company in war may actually act through the secondary war organs. You get, provided that these secondary organs have been authorized by the primary organs. And that's why you see that A says the act of your secondary organs, they are not the act of the company, except where you can show that what you have been expressly authorized. And that's why I tell you that when you read section 91A, it will take you to the types of what? Of authority that we have. Told you about what? The actual or express war authority. Do you understand? So if a single director is acting before the company can be held liable, you must prove that what? That he has what? The actual war authority. That's expressly authorized. That express war authority. That it was the board of directors. It was the board of directors that was authorized for him. It was the members general meeting that authorized for him. It was the managing director that authorized for him. Or impliedly war, he said either what? Expressly or impliedly authorized. Meaning that what? It is not only when it has what actual authority, it can also have what? Implied more authority. Now ask yourself, what does it mean when you talk about what implied more authority? From our law of agency, when we did a law of agency, should have come across all these types of authority. Actual, express, implied, usual, customary, ostensible or apparent for authority. All of these, they become important as far as this particular topic is concerned. You know actual authority. Board of directors make decisions. They say, okay, use this remote director or a committee and do it. That's actual authority. Or members in general meeting do so. That's actual authority. But when we say implied authority, when an authority is said to be implied, it means that not the word expressly or conferred. But then the court or the law is saying that looking at what the general circumstances, if a third party, the third party is an invisible third party. That if a third party had come and say, wait, both of you guys just spoke about what that Sheung can kick off with the business of selling rights. But we did not say anything about whether Sheung has authority to withdraw money from the bank, or whether Sheung has authority to meet outsiders, whether Sheung has authority to carry out advertisement. You did not give Sheung all of this for authority. That what implied authority is saying that if there had been a third party, if the third party had made that point, that you guys would have said, oh, of course, now, even though we did not say it expressly, Sheung needs all this authority in order to be able to live out its actual authority. Like you did not say it, but it is taking that, of course, it's common sense. Now, when we give you an authority to do this, we don't need to give you authorities to be able to work. So there are some things that will flow from that actual authority. That's what is known as your implied authority. Are you following? So, meaning that when the board of directors, for instance, confers an authority on a particular director, that okay, we want you to do something. That is actual authority. Are you following? But in the course of exercising this actual authority, there are some things that the director will need to do. And when he does it, even though he has not been expressly he did not expressly say that he can do it. But from the one that he said he can do, you automatically know that he has to do this in order to be able to achieve it is implied that he has the authority. Do you understand what I'm saying? So that is your implied your implied authority. You don't understand the implied authority. Now this is it. That's what you should have understood. The implied, when something is implied, okay. Have you ever used this expression that when you implied it? Have you ever said anything like that before? Whether with your friends or whatever? But you just said something like that, but you implied it. You said something like that before, right? And I'm sure that anytime you say something like that, but you implied it, it must have been a response to, but I didn't say so. That was not what I said. Do you understand what I'm saying? And then you respond by saying that, but you implied. When you say that something is what is implied, you are saying that the person did not actually say it. But from it, you know that the person has indirectly actually said it. So we're not linking this. And I said, say for instance, you are a director. And the board of directors now, for instance, now say they decide, okay, we want to say maybe declare dividends. And they now appoint you as the director to handle it. That's the only thing they said. They said, we give you the authority to handle it. Of course, they didn't give you authority on do this. But they have given you the general authority to handle it. Do you understand? It is implied that you have the authority to do everything necessary. Do you understand? To carry out the assignment. Is that understood? So if, for instance, you give the authority and say, about having classes, we want to change the timetable for class. Don't want to have it at this social time. We want to have it at this social time. Of course, the day we voted as our class rep and everything and all, we've given it the actual authority. Do you understand what I'm saying? But in the course of changing the timetable, we did not give the authority to go and meet the dean. Whether they will give the authority to go and meet the subject that is actually expressed. We did not say go and meet this person. No, we did. We just told to make sure that this issue of maybe causes passion and everything should be resolved. Say if in idea that the has gone to meet something, are we going to challenge the that we give the authority to meet something? We cannot challenge the because the day we gave him the authority that he should make sure that these causes are clashing, that they are resolved. they have also given him what the implied authority to meet what the necessary authority that can work. I don't see to our problem. Do you understand? So it's not until they show that he was actually given what the authority before he said that he has the authority. It may also be what they imply. Oh, that is that. Then we have B. Okay, I asked you a question. I said, what if the officer is not expressly or impliedly authorized by the company? Will the company still be bound? If the this is not expressly, has not been expressly or impliedly authorized by the company, will the company be bound? Sorry, Peter, I want to cancel my F4 class because we have to spend more time. Alright, yeah, just try and answer the question. Will the company be bound? If the officer or agent has not been what? Expressly or authorized, will the company be bound? Ask you because you are trained. 90B says the officer now, before the act of the officer will be the act of the company. But that will be what? Expressly authorized or impliedly authorized.
Okay, so
now, if the officer, let's say the director, the secretary, or whatever, did something and there's no actual authority and no implied authority, will the company still be bound? Yes.
If it's acting in that way and then they don't caution, because those third parties
They don't be implied.
it's already implied because it's the company of the
Eh? Every time third party is involved, he is already implied. What if you may have been their long-time customer and you know that this one does not have authority, or you had knowledge of
that's why the second part, that's why the second part says, except the person has knowledge.
the second part. 90 what? B. Okay, what does it say?
And then unless such person has actual knowledge that the officer or agent has no authority.
I mean, no, you people, these things in our last class, and I gave you that, I told you the answer is yes and no, depending on the what, on the circumstances. There is no yes, there is no no. The answer is what? Yes and what? No, depending on the what? On the circumstances. If the officer does not have what? Authority, are you following? But you did not work? No. And you are not in a position to have actually worked? No. That is the headache of what? Of the company, because the law will protect what? The third party. Do you understand? So if the third party does not have actual or reported knowledge, then the company will still be bound. Are you following? But if the third party had what? Actual or reported knowledge, then the company will not be bound. And I also told you that also, if the company should confer ostensible authority on the officer, fine, you did not give him express authority, you did not give him implied authority, but you saw that what he kept doing this and you appeased in it, you allowed him, you heard him out, you gave the third person the impression that he has got the power. In that instance, the company will be bound. And I told you that even this, the answers here that I provided, it was based on reading 89.1, 89.1, and then 90 together. But there is a particular provision in the act that even provides what? An answer to this question. I was expecting you to even think. 90 what? So what does 90B say? Oh yeah, let's read that 90B.
The company acting as mentioned in paragraph A shall have represented the officer or agent as having the authority to act in the matter, in which event the company shall be civilly liable to any person who has entered into the transaction reliant on such representation, unless such person has actual knowledge that the officer or agent had no authority, or unless having regard to his position or relationship to the company, he ought to have known of such absence of authority.
Do you understand? You see that your 90B actually made reference to the actual knowledge or what? Imputed knowledge. So if the officer does not have the authority, but you knew, then the company will not be liable. Or you want to no, then the company will not be liable. Are you following? And I told you that if the company then holds the officer out, that is where your ostensible authority comes in, and that's where Freeman and Lockyer and the Locus Park will become relevant. Hello, the Freeman and Lockyer. So Lord Deep Lord said, he said, see, when we are talking about what ostensible authority, Ostensible authority means that what the third party does not need to know whether what the officer has what actual war authority. Whether the officer has actual authority is the business of what the company and the war officer. Hello, they are the ones that we know, but they should give you the impression that what he has what the authority, then he cannot turn war around. That's why you see that ostensible or apparent authority stems from what agency by war estoppel. You are not allowed, the law will estop you. You are not allowed to turn around and say what and say this. Are you following? Now, what about 90 sub 2? Hello? Okay, I think that was where we stopped in our last class, Abby. Yeah. Okay, so we start there. 90 sub 2. Moved those classes. What does 90 sub 2 say? 90 sub 2 says the authority of an officer or agent of the company may be conferred prior to any action by him or by what subsequent or ratification. Of course, let us take that part of it. See, makes sense out of the entire 90. This is how to make sense out of section 90. Section 90 starts by saying, you are not listening. Section 90 starts by saying that first, the first thing says that acts of what? Officers or what? Agents are not what? Acts of what? Company. That's the first thing that section 90 says. Is that not true? Hello, is that not true? The second thing it says is not that what? Where the officer or what? Agent has actual or implied war authority, the company is bound. Is that not true? Is that not true? Hello, is that not true? Yeah. Section 90 is also saying that even where the officer lacks what? The authority, if there is actual or imputed war knowledge, the company is not war bound. Is that not true? We have established all of this. Is that not true? Yes. Essentially, section 90 is saying that for the company to be bound, the officer must have what? Authority. The officer must have what? Authority before the company will be bound. The authority may be actual, that is express. Maybe what? Implied. And I told you can also be what? Ostensible. At times you may see it as ostensible, at times you may see it as what? Appearance. That is the idea. The officer must have what? Authority. Any of these what? Authorities before the company can be what? Bound. Hello? Now you see what your 90 sub 2 has done is to tell us when to confer this war authority. When what? 90 sub 2 is just telling us when to what? To confer what? This war authority. The authority may precede the act or may be what? Subsequent to the what? To the act. The act is not the law as the action of the officer or the agent. They may have conferred this authority either before or they may confer it to after. How do you confer authority before? By following what the law says, you confer what? Authority. But how do you confer authority after? If an authority is conferred after, that means that act had initially been done without what? Authority. Hello? Do you get what I'm saying? If an authority, 90 something, is just telling us that, okay, the thrust of section 90 is that the officer must have authority for the company to be bound. Are you following? I mean, I've looked at all the types of authority that they want. 90 something is just telling us when the authority can be conferred, whether actual or what's it called, implied. When it can be before the act, and before the officer goes ahead to carry out the act, or it may be after the act. If you are being conferred with the actual authority, of course, it means they are giving you the authority before you acted. And I've told you, how do you give an authority before the person acts? Of course, that must have meant what? In line with the way the law says you should give what? The authority. If you are giving an authority after an act has been carried out, I'm saying that means the person carried out what? The act first without what? Authority. Because if the person carried out with authority in the first place, why do you want to give authority again after the person has done? Are you following? Do you understand that? So, meaning that when we are talking about what? Authority that is conferred subsequently, that means we are also looking at instances where the officer has acted without authority. Meaning that it may be one of those instances that the company is ordinarily not supposed to be bound. But the company can also accept to be bound, and that is what is known as ratification. You can see that your city, everything is just coming out. You used to remember ratification. Yes. All those Folashade and Roshola and all. Do you remember? You don't remember ratification? Do you remember the Rama's case? Yes, sir. How would you do it? Rama's case. Ostensive, that's where they laid down all the conditions when the agency was expected for it to have. Because frame and local is sufficient. I want to talk about ostensive, particularly the judgment of the diplomat. I will send you guys the link on one article I wrote on the 20th. I will look for it and send it for those of you that are interested in it. But when we are speaking of this, we are talking about ratification. Now, of course, what the essence of 90 sub 2 is to more or less codify. To codify what? The common law or rule of on ratification. Now, the whole idea of ratification is where the agent acted without authority. But then the principal decided that what? Okay, I go ahead, I will take it. So whatever it is that you have done without what? Authority, then I confer authority. So what you have done should be seen as what? I have done it. Is that not so? I told you the underlying principle behind the law of agency. He who acts through another acts for himself. So from the beginning, you are not acting through the officer because no authority has been conferred on the officer. But what do? Later you now confer the authority. So what that person has done will be taken as what you have done it. So you have to be careful even in the exam. When you see the question and you see that you're already moving to the part of, this particular officer or agent does not have authority, and the third party does not have actual knowledge or imputed knowledge, and the company has not given ostensible, and you want to quickly say the company is not liable because you say, that means this officer does not have authority. Be careful and read the question all through to see whether the company has not ratified. Because the moment the company ratified, you see that wrongdoing by the officer will become valid and will be enforceable against the company. It is just more of, I am here and let us say I'm just coming upstairs. And that woman downstairs is just like one of your friends, so you guys are staying together. He said you asked me to give him what is it called? Maybe mineral, so to say, soft drink and all that. And I know that I don't tell any of my friends to go and collect any soft drink. Something will back on me. Right? No, I don't tell any of my friends that this is scared. So what I tell him, I did tell him, when you see him, collect money from him. Do you understand? But then I may look at it that this guy, this is it. Okay. Rather than asking the woman, I didn't give him the authority to come and collect the drink. Collect your money from me, he should be held more liable. I can decide to now confer that authority that I didn't give Uber after he had already collected the soft drink. Meaning that I say, okay, alright, no problem. Pick out money and then I pay the I can now come around and I change it for Uber until I say, but this one I just gave you this one, I decided to take responsibility for your wrongdoing. The next time you go and use my name to collect your drink, you can say, go and use my name to collect drink again. The next time it will be what? It will be on you. I don't know whether you understand what I'm trying to point. Trying to show you how you can ratify. Do you remember all this practicing case? No. These are cases that you have on ratification. You know, when you want to ratify, there are certain things that you must do. Hello? There are certain conditions. First, of course, you must inform the principal what you have done. But the principal should give informed consent, because he knew about all the facts and circumstances. And also another thing is what? Is the fact that what? The principal must be what? In existence. Hello? The principal must be what? In existence. So that was why you see that all this your case of Caligari, this case of Caligari versus Giovanni Santoro. There are so many cases like this, but I remember Caligari versus Giovanni Santoro. These were cases that were more of, you cannot ratify when the principal was not in existence. Do you understand? But you see that is why the section 96, former section 72, talks about how the company can ratify every very completed contract. People will be learning in isolation. Once you learn this one, it's there like that. And now everything works. So even for being completed contract, the company can decide to ratify. Do you understand what I'm saying? Yes, all those cases of Kellner and Baxter. Kellner versus Baxter. These were cases that said if the principal was not in existence, the company cannot the principal cannot ratify. So it used to be then that for incorporated contract, if you have not incorporated your company and the company is not in existence, so it used to be that we say that the company cannot later ratify. But you see our former section 72 of PAMA, which is now section 96 of PAMA. So the whole idea is that the company can actually decide to ratify the act or the wrongdoing of the officer or agents. Do you understand that? But then this proceeds to say that I said the authority of an officer or agent of the company may be conferred prior to any action by him or by subsequent ratification and knowledge of such action by the officer. Knowledge of such action by the officer or agent and acquiescence by all the members of the company or by the directors or by the managing director for the time being shall be equivalent to ratification. Knowledge and acquiescence. Hello? Knowledge and acquiescence of the action by the officer or agent by either the members in general meeting, the directors or the managing director for the time being shall be equivalent to ratification by the members in general meeting, board of directors, or as the case may be. Now I told you, I said, even from the common law position of ratification, one of the requirements of ratification is that your principal must You must inform your principal. Your principal must have knowledge of what you have done. I can't remember, I think it's the Pakistan and King case or thereabout, where the agents, after the agent had done that particular thing without authority, now told the principal, but he did not tell the principal the full facts. So it was later after the principal has already ratified that the principal now realized that you did this too. If I had known, I wouldn't have ratified. And next time because that ratification was invalid. Are you following me? That ratification was invalid. Why? Because you don't have knowledge, the full knowledge. So I suppose this is what they also mean that you see knowledge. The board of directors, the managing directors, or the members in general meeting, they must have knowledge of what? Of the action of the officer before they can ratify. Do you understand? Hello? They must have what? They must have knowledge. It's not enough to just say you ratify. They must have knowledge of what? Of the action of this officer or this agent before they can then ratify. Okay then, 90 sub 3. 90 sub 3 says, 90 sub 3 is on vicarious liability. On the vicarious liability of the company. It says, nothing in this section shall derogate from the vicarious liability of the company for the acts of its servants while acting within the scope of their employment. You know the principle of vicarious liability in torts. You still remember vicarious liability in torts?
Yes.
That's the principle of deep pockets. What we call deep pockets. Principle of what? Of deep pockets. Now, before a company or before an employer or an organization will be vicariously held liable, one thing you always understand is that it was not the employer that acted. It must have been the what? The employee or the servant. It used to be master servant, but later they turned it to what? Employer-employee relation. That's one of the requirements for vicarious liability. Do you understand? So it used to be that, okay, this person has what? Acted, not what the company. But, and this person has actually what? Acted beyond what? Beyond his law, has done something wrong. But what this person did wrong was within what? Within the scope of his what? Of his duty. Of course, if let us say you own a school, let's say you own a school, and you have all these school buses and the likes like that. So of course you are going to employ drivers. So when you have your driver, and it's time for your driver to take to ferry the children back home, did you tell the driver to go and hit somebody to commit accident? Do you understand what I'm saying? Of course, that's not what you told the driver to go and do. But while the driver was carrying out his duty, the driver then he got involved in an accident. Now, ordinarily, the third party or the victim of the accident is supposed to bring the action against against the driver. Are you following? In fact, you, the employer, are saying, well, I said you should drive, and you say you should go and get involved in in an accident. So ordinarily, you're supposed to bring the action against the primary person. Do you understand what I'm saying? But the principle of deep pocket in the sense that the reason you normally want to bring an action under vicarious liability is because you feel like the person that actually caused or that did that will not have enough money to compensate for you, and that it is the employer that will have that money. So the employer has a deep pocket. So you just with one year officer, and the person was discharging his duty. Maybe the person was negligent. This time around, we are not talking about the person going beyond scope. The person is acting within his authority, but something now happened. Are you following? He's acting within his authority, because he now did something maybe by way of negligence or whatever. So you want to bring an action. Do you get? You want to bring what? And okay, maybe you have the gatekeeper. You have the security guard. He is doing his duty of closing gate and blah blah. But one way or the other, when you are about to just step and leave, he did not even take time to wait for you to leave. He just jammed the door, and then the door hits you, and then he sustain and injury. Do you understand what I'm saying? Sustain and injury. Of course, did the company give the gatekeeper the authority to hit? But they said, watch the ingress and egress. People that come in, people that go out, shut the gates, open the gate. So it was still acting within his scope of employment when he did that thing that was wrong. Are you following? So ordinarily, you bring an action against him. But because you know that in this one, you wouldn't have money, and you want to make money out of this. So what do? You then sue the company that has a deep pockets. So what this your 90 sub is saying that you see everything that we have been talking about, the liability on the company, it does not still stop the company from still being vicariously liable. Do you understand? That is, does not stop the company from being liable where any of the officers or the agents, while acting within their scope of employment, does anything wrong. Are you following? Are you following? But I understand that for 90 sub 3 to apply, that means you have to prove all the elements of vicarious liability. You know, the employer-employee relationship. Do you understand what I'm saying? Okay, there must be employer-employee relationship. And first is that, also, what is the second one? That's the third one. And it must be in the course of employment is the third one. What is employer-employee? And then there must have been some sort of like a breach or something. You must have done something wrong. Are you following? But what you did wrong must be done within the course of employment. What did he say? There must have been some sort of damage or something like that. Do you understand? It's supposed to have done something wrong. That's why we are bringing We are bringing the matter under vicarious liability. Do you understand what I'm saying? So it must be within the course. It is the issue of within the course. Okay, like this example I gave now, that he was driving the company's bus. That was when he had the accident. What about if the company said, okay, go and deliver something at Ikeja. But before going to Ikeja, he wanted to go and meet his girlfriend at somewhere. You understand? Like a detour. Do you understand? So then he was frolicking. That is what we call it. We cannot continue looking at vicarious liability here, but the whole idea is if you understand vicarious liability, you understand what 90 something is talking about. Are you with me? Then let's look at abolition of constructive notice. Abolition of constructive notice. Section 90 something. Where is that finished material? I will need it now for some of these pieces. Abolition of what? Of constructive notice. Now, someone should read out section 92 for us. Oh yeah, who is reading section 92 for us?
Except as mentioned in section 223 of this Act, regarding particulars in the register of particulars of charges, a person is not deemed to have knowledge of the contents of the memo and articles of the company, or any other particulars, documents, or the contents of documents, mainly because such particulars or documents are registered by the Commission, or referred to the particulars of documents so registered, or are available for inspection at the office of the Act.
Now, section 92 says that, of course, except as mentioned in 223, regarding particulars, blah, 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 blah. The one that is important for us is that it says a person is not deemed to have knowledge of the content of the memo and articles of the company. You have to note it all. A person is not deemed to have knowledge of the content of the memo and articles of of a company or any other particulars, documents, or the content of documents merely because such particulars or documents are registered by the Commission or referred to in the particulars or documents so registered or are available for inspections at the office of the company. Now, you see, the abolition of constructive notice is very important if the law wants to create a balance between protecting a blameless third party and not protecting any third party that is blameworthy. Now, you guys, listen up. You know that the philosophy of our corporate regime is to make sure that the government tries as much as possible to protect outsiders. Are you following? That is third parties that are dealing with the company. Do you understand what I'm saying? They want to protect them. But that is provided that the outsider too is not also guilty of any malfeasance, so to say. So you saw all those issues of actual knowledge, imputed knowledge. You see that there are exceptions to the protection given to the third party. If you knew, then you're not protected. You're only protected because you did not know, and not in circumstances where it could be shown that you were negligent. You should have known. Do you understand what I'm saying? Now, the abolition of constructive notice, you cannot claim to protect third party by way of knowledge that did not have actual knowledge or imputed knowledge, and then you still give constructive notice. You have to abolish constructive notice. Constructive notice, of course, was part of the common law rule. Now, you understand that documents such as memorandum of association, articles of association, they are public documents. And when a document is said to be a public document, it means that it is open to the entire world. Is that understood? So if you want to deal with a company, you are more or less expected that you should have gone ahead to check the content. Are you following? So that you'll be able to know on what you should deal with the company Now, if you did not check, that's not you. Are you following? If you not check, that is on that is on you. So constructive notice says anybody that is dealing with a company, you are assumed, you are deemed to have already checked all the documents. Why? Because the documents are with the company's registry. It's open to you. You should have gone ahead here and check it. Hello? Meaning that with constructive notice, if a company, constructive notice was also used to back up the rigid or trial doctrine under common law. It used to be like this. Say for instance, the company has this in their what? The company has their memorandum of association, and they stated what the objects, but they did not state that they can deal with what in cryptocurrency. Of course, before the company will be incorporated, in their memo that they've already stated the objects, what would happen? They would have gone ahead to submit it to the world, to file it with what? The company's war registry. Now you're not dealing with what? With the company. On what? On crypto war currency. After you guys have done all your dealings and everything, only for somebody to challenge it and say that, oh, no. You cannot hold the company liable because you have dealt with what? The company on what? On something the company does not have with war memo. Do you understand? Now you now want to say, well, I did not know. I didn't know that what was not stated in the war, in your memo. The effect of what constructive notice was to say that you are jailed towards you are war. No. We did not know it's on you. That's your problem. Because the document is what is open to everyone to go to check. So more or less of why didn't you check? If you had checked, you would have found out that what this company does not have the power to do war. So do you understand what I'm saying? But now you look at this. Supposing that we still have constructive notice in Kama, would it not rubbish many of the words of the provisions that we have already examined that tends to protect our third parties? Would it not rubbish it? Would it not rubbish it? He said yes. What are those provisions into rubbish? If constructive notice was not abolished, what are those provisions that you want to rubbish? Actual knowledge, call actual. But 90 words. 90 words. 90B that says what? Actual notice. Yes, talks about sensory authority. You did not see the one that says that the company will still be liable, and it will not lie in the mouth of the company to say that, oh, the business or the particular thing they've done is not for part of the business that what they have authorized in our memo. It will rubbish it now. Because by now the company will not be able to say it that but we stated it in what in our listing. And I told you it also rubbish your 44 sub 3. So the 44 sub 3 will become useless if we still retain constructive notice. What does 44 sub 3 say? In your travail. It says something about the fact that if any transaction has taken place, any conveyance of land or whatever with a third party, you understand? It will not lie in the mouth of God. That particular contract will not become invalid simply because the company has acted on travail. Are you following? So, constructive notice needs to be abolished so as to give life to some of these provisions. If not, there will be inconsistency. Because now you are saying that I did not know, but I'm taking to have known. Hello? If I'm taking to have known, does that not amount to some sort of imputed knowledge? Do you understand what I'm saying? I did not know, but I'm taking to have known. So they have to abolish constructive notice and say that okay, it's either you knew or based on your relationship or the position you want to have known. Not just that it should be imputed that simply because they have submitted anything to the company's registry. Everybody is now taking to know the content of the memo. No. That is just still to protect you. Now, when we're talking about constructive notice, and I was reading this book, said something about the fact that the abolition of constructive notice under section 92 as more or less. Will you help me? Yes. And it has more or less codified the ruling in what we call the indoor management rule. How many of you know about the indoor management rule? In the case of Royal British Bank versus Stock One, in the case of Royal British Bank versus Stock One, that's what they call the indoor management rule. The indoor management rule is simply to say that, of course, there are certain things that the company they want to do within that particular war business concern. That the person that is what outside will not war no. Say for instance in your articles of association, say for instance you put it there that okay the company has war power to maybe delegate a particular task to what to a director. Now you saw that in the articles of what association. Hello, are you following me? That's what you saw in the article of association. It now dealt with what a particular war director. The director that the company that they said in the what article of what association that they can what delegate to, and they have to confirm with that thing war on. Now dealt with the person. Only for the company to now say, before this director could actually act, you know, that was authorized was him or appointed him or things like that. They're not telling you that they not appointed. Because how will I know as an outsider that this director is appointed and this one is not appointed? That's something that what it is the internal war management of what of the company. That's what we call the indoor management war rule. So in top one, let's see what happened in Royal British Bank and top one. So the articles empowered the directors to borrow up to an amount authorized by a company resolution of the general war meeting. So when the general meeting meets, they authorize a particular war amount, and they say what directors can actually borrow up to that war amount. The company had given a bond to the bank, which was under the company's seal and signed by 2 directors. The company, however, denied liability, alleging that there was no resolution passed. You know, they said they must pass a resolution to authorize the directors to determine the amount. So the company said there was no resolution war passed authorizing the issue of the bond and that it was given without authority. However, the court held that the company was bound and that the bank could enforce the terms of the bond. The court said that any parties dealing with companies are only bound to read statute and deed of settlement. This is very important. The court said in that top one case that parties that are dealing with companies are only bound to read statute and deed of settlement, meaning that you are only bound to more or less know what the law says. The deed of settlement are more or less equivalent to your memo and your articles of association. Are you following? But are not bound to do more. The parties are only bound to read the articles of association, the memorandum of association, and the law. But aside that, you are not bound to do more. And so the court said that there was no prohibition on borrowing in the deed of settlement, and this is the articles of association, but a permission to do so on certain conditions. Because finding that the authority to borrow could be by resolution, the bank has the right to infer that such resolution has been legitimately done. So if you give somebody authority to do something in any of these documents, do you understand what I'm saying? Of course, it's not my own duty to now be investigating whether that person has been given the authority, because even if you try, you may not be able to verify, because that is within the company. You as an outsider may not know. Hello. That is within the company. You as an outsider may not know. Now, one thing I want to bring out from this indoor management rule, this Royal British Bank and top one, that I think that many people have not actually paid attention to, was actually the fact that you see, as at the time you decided this particular case, see that constructive notice was still a part of English law. Are you following me? Constructive notice was still a part of English law. So meaning that they wanted to argue that you must have known that this person had not been given, that resolution had not been passed. So the court was simply distinguishing the scope of constructive notice in Royal British Bank case. That when we're talking about when we're talking about constructive notice, they will always say you are deemed to know. But the question is, what are those things that you are deemed to know? It's not everything. It's not anything that has to do with the internal management of the company. No, it has to be anything that has been put in the public. That's why you see that JVCJ said parties dealing with companies are only bound to read statutes, and deed of war settlement. That is the only thing. You are only bound to know what the content of war, articles of association and war, memorandum of what, association. Not for you to know whether the person that they said they can give authority, whether that person, whether the resolution has been passed, or whether the director has been duly appointed. You cannot know. Are you following? You cannot war. No. The only things you are supposed to know are all those public war documents. So even a Royal British War Bank, that particular case still recognized constructive war notice. It only limited or defined the scope of war, constructive war notice. Only that the only notice that will be construed by the law is any notice that does not involve the indoor war management rule of the company. I don't know whether you understand this. Top one. TURQUAND. I say so many things now. Even me, I can't even. Which one did I say? What I'm saying is you see, what I'm saying is this. Because when we're talking about this Royal British Bank and Top One and all, ordinarily, it is when you are talking about presumption of regularity, most times that they cite this particular case. Of course, they cite it to along with the abolition of war, of constructive notice. I've explained what constructive notice means. Is that not so? Constructive notice is the fact that they said all these documents that are made were public, either by being made available for inspection at the company's office, or they have been filed with the company's registry. So they are more or less public documents. You are expected to go and check them before dealing with a company. Are you following? If you do not check it, you are on your own. You are construed. That's the idea of constructive notice. It is construed that you were aware. Do you understand? So in this particular case, this Top One's case, Top One's case was more of a case where they now wanted to argue that the law construes this notice, that you are supposed to know that we have done passed a resolution. So that was why that case now tried to define the scope of constructive notice. That no, when we are talking about constructive notice, the parties are only meant to check the law, as in the statute, or the deed of war settlement, more or less, which are equivalent to your articles and memorandum of war association. That is what they need to know. Anything that has to do with the indoor management rule, that has to do within the company, as in questions as to whether a resolution has been passed to something that you have already said that somebody has authority to carry on, or whether a director has been appointed, that is within the company. Because the third party can try and may not still be able to find out whether the director has been appointed. That the scope of constructive notice does not extend to that. Are you following? You see Top One rule, this is your presumption of regularity. It's only there to redefine the Top One rule. Top One rule limited the scope of construction. You know what is going to happen? This is what is going to happen. We are going to end the class here today. In our next class, we will start afresh with constructive notice. The reason I'm stating all of these things is because you are going to read material. You are going to read some of this material, and you will not understand them. You just know constructive notice, you see Royal British and Top One and all, and then you go into the exam hall. And then you not see problem questions, or you see any essay question, you not be able to Next class is on Saturday, and that one is only normal 12 to 2. That is only partnership. So 2 hours will be on partnership. So you guys can leave so that I can take care of my first students.